Hi, welcome to the housing module. This video will be the first of 4 looking at the housing-related civil legal issues that your clients might experience. This first video is going to be taking a look at some general information on housing law in Ontario. Let's start by taking a look at what this video will cover. We'll start by taking a look at some of the housing laws in Ontario and what protections might be available to your clients under those laws. We're then going to take a look at the Landlord and Tenant Board and when your client might have to interact with that board. After that, we'll go through the legal eviction process in Ontario. This process is going to play a big part in the next training video on evictions, so we'll just cover some introductory pieces here. Finally, we'll wrap up by taking a look at some common issues that might come up with illegal evictions. Let's first start by taking a look at some of the laws that might apply to your clients. In Ontario, there are 2 key pieces of legislation which regulate housing issues. The first is the Residential Tenancies Act. This act describes landlords and tenants' rights and responsibilities. It also has rules that govern the relationship between a landlord and a tenant, including rules about things like rent increases, evictions, as well as maintenance and repairs. The second key piece of legislation is the Housing Services Act. This act contains rules that municipalities have to follow when administering social housing. This includes things like wait lists for access to social housing, as well as rent geared to income subsidies. Now let's talk about one of the most important protections available to your clients under the Residential Tenancies Act. A tenant who's covered by the Act won't be able to be legally evicted unless their landlord follows the legal eviction process. This process has 5 key steps, but we'll be talking about those a little bit later on. What those steps mean is that if your client's living situation is covered by the Act, their landlord will need to do multiple and specific things to evict them, including things like getting an eviction order from the Landlord and Tenant Board. But that act doesn't protect everyone. So if your client's living situation isn't protected by the act, then they can be evicted without notice and without their landlord following the legal eviction process. But how can you know if your client's living situation is protected by the act? The Residential Tenancies Act applies to rental housing in Ontario. This includes things like rental houses, apartments, mobile homes, and retirement homes. It'll also apply to some, but not all rooms. But the Act doesn't apply to other types of situations. For example, someone who shares a kitchen or a bathroom with an owner or an owner's family. Someone who rents and uses a space for both business and living, like someone who lives in the apartment above their store. Someone in seasonal or temporary housing, like a hotel or a campground. Someone who's in a shared rooming situation where not all the roommates are listed on the lease. And some community and social housing arrangements. We're not going to be covering these exceptions in this module, but sometimes it can be hard to tell which category your client's living situation will fall into. So if you or your client have questions or concerns about their living situation, it's best to get legal advice. Another thing the Residential Tenancies Act does is give power to the Landlord and Tenant Board to deal with housing issues and disputes, including making decisions at eviction hearings. This board has local branches across Ontario, but does both virtual and in-person eviction hearings. If your client is being evicted, they might be getting things like forms, letters, or other documents from this board. This is because the board plays a key role in the legal eviction process in Ontario. This process is another protection created by the Residential Tenancies Act. So let's take a look at that process now. If your client's living situation is covered by the Act, they'll be protected by Ontario's legal eviction process. Because of this process, a landlord can only legally evict someone if they go through 5 key steps. Step 1 is the notice of termination. Step 2 is the application to evict. Step 3 is the eviction hearing. Step 4 is the eviction order. And Step 5 is the notice to vacate. How you can best support a client going through this process will depend on which step they are at in the process. The earlier it is, the easier it is to take action and save their housing. But we'll cover that in the next video. For now, let's just take a look at each of these steps and what you can expect. Step 1 in the process is the notice of termination. This is a written notice that a landlord has to give to their tenant to begin the eviction process, and it must be done on one of the Landlord and Tenant Board's official notice forms. Anything else won't be enough. That means if your client's landlord gave them a verbal notice or sent them an email or a letter, that won't count, and the eviction process will not have been started. This notice should have important information, like your client's name, the date that their landlord wants them to move out, and the reason why their landlord wants to evict them. They also have to be given this with sufficient notice ahead of the move-out date. How much notice is required will depend on the type of eviction, but, for example, if your client is being evicted for owing rent, their landlord generally has to give them 14 days notice. But if your client is being evicted for causing damage, their landlord generally has to give them 20 days notice. It's really important that notices are completely correct. They need to be on the right form, they need to be provided with sufficient warning, and all the information on that form must be accurate. This means that your client's name, any amounts owing, and any reasons for eviction must be sufficiently detailed and correct. If the notice isn't canceled or voided, the landlord can file an application to evict. This is step 2 in the process. The landlord can file this application with the Landlord and Tenant Board. This application lets the board know that your client's landlord is trying to evict them. If your client has received an application to evict, they should have also received a notice of hearing. This notice will tell them the date and time of their eviction hearing. The eviction hearing is also step 3 in the eviction process. While the hearings happen with the Landlord and Tenant Board, these can be done either virtually or in person. These hearings give an opportunity to both the tenant and the landlord to tell their side of the story. And then the board will decide whether or not to evict the tenant. It's really important that your client attend any eviction hearing that they have. If they don't, an eviction order will almost certainly be issued against them. At this hearing, your client will have the opportunity to tell their side of the story. They'll also be able to present evidence of things that they think the board should consider to not evict them. This can include things like how long they've lived in their unit, if they've recently lost their job, if they have a disability, or if they're low income. Things like that can be very powerful to tell to a board member on the day of the hearing. Your client can also share things or present evidence that might offset their landlord's position. This can include things like pictures of damages or things that need fixing, as well as repair estimates or receipts. Your client should come prepared for this hearing, and there are ways that you can help them do that. But we'll talk about that a little bit more in the next video. If the Landlord and Tenant Board decides to evict your client, they'll be in step 4 of the eviction process. Step 4 is the eviction order. This order will set out the reasons for the eviction, but it might also give your client some information on things that they can do to stop the eviction. The most important information on the eviction order is going to be the termination date. This is the date that your client needs to move out on. Once that date has passed, their landlord will be able to file that eviction order with the court enforcement office, which is also sometimes known as the sheriff. Once that order is filed, your client will be in step 5 of the eviction process. Step 5 is the notice to vacate. This notice is provided by the court enforcement office. But not all court enforcement offices across the province will give tenants this type of notice, and sometimes they do just show up and evict someone without warning. If your client does get one of these notices, it will tell them the approximate date and time of the eviction. This can help them prepare and protect their belongings. But sometimes a landlord might not follow the legal process. So let's take a look at some common issues that might come up if your client's landlord is trying to evict them illegally. The first thing that might come up is a landlord threatening to evict your client. We know now from the 5-step process that a landlord can't just threaten this. A landlord has to get an eviction order from the Landlord and Tenant Board to actually evict your client. So your client should have received official paperwork from the board if the eviction process was started. Remember, emails, verbal conversations, or a handwritten eviction note won't be enough. The second thing that can happen is a landlord changing the locks. It's illegal for a landlord to do this. Even if they get an eviction order from the Landlord and Tenant Board, their landlord still isn't allowed to change their locks. Only the court enforcement office is allowed to do that. So if this happens to your client, it's considered an illegal lockout, and your client should get help immediately. They can get help from Ontario's Rental Housing Enforcement Unit or from a local legal clinic. And that wraps up our general information on housing. Until next time.